All right, once again, kiddos, it's a Monday, February 10th, 2025. Gods of YouTube. YouTube algorithm. This is not legal advice. This is public information that I just wrote that got submitted to a governmental website. There's no privacy concerns. Nothing that shouldn't be redacted. All that good jazz. It's newsworthy and informational purposes. So anyway, I checked the docket. I was seeing it's Monday, and I've refiled those 9 motions plus 4 more motions that the judge declined because he didn't like the electronic signature. So those were originally submitted back in January. So he's going to take a couple weeks, find another reason to deny everything. But I'm sitting here thinking, and I've been thinking this for a while. They try to have me, Amber, in retaliation, Amber Smatwell, my 8th attorney, in retaliation for filing a bar complaint. She tried to have me deemed mentally incompetent, wrote these motions addressed to Pinellas, and then Frank signed off on them, and then the stripper lawyer, like I said, backed her in her corner, and she realized I didn't need to get a competency evaluation, because a competency evaluation, they use it on people that, are vocal and they don't just lay down like dead fish. If you look at the law, which they don't follow, competency issues are raised when the defendant is not able to effectively communicate with their attorney. And Pamber would never answer the phone. Everyone that's been here knows that. She blocked me on every platform, everywhere. And to understand the adversarial nature of the courts. Man, is this ever adversarial? We're going on 3 years of this. 3 years of this next month. So anyway, I'm like, let me go ahead and file another motion. So I did a motion to challenge judicial inconsistency and incompetency determination and to enforce ADA accommodations. Always bring up your rights, as often as you can. I keep demanding ADA accommodations and competent and ethical legal counsel. They won't give it to me. So yeah, comes down to defendant Tasha Teeling, pro se, forced to appear pro se. Should use my all caps legal straw man in here. Maybe that's what they want. Moves this court to address the inconsistency in its determination of her competency and to ensure her right to ADA accommodations. The court's contradictory actions, previously attempting to declare the defendant incompetent to stand trial, yet now forcing her to proceed pro se without counsel or accommodations, can constitute a violation of her due process rights, ADA protections, and equal access to justice. In support of this motion, the defendant states as follows, and I just submitted this as e-filed 2/10/2025, 1:58 p.m. This is all I do all day for the last 3 years. Study law, draft motions, and they don't care about the law. Then you encounter these cops, and somebody calls the cops, and you lose your rights immediately. And they'll be like, and then you try to stand in your rights and be like, "What law school did you go to? Where did you graduate law school?" These freaking road pirates practicing law on the side of the road without a license. But anyway, so approximately 1 year ago, the court attempted to declare the defendant incompetent to stand trial, raising questions about her ability to understand the proceedings and adequately defend herself. Despite this prior determination, the court is now forcing the defendant to proceed pro se without legal counsel and without reasonable accommodation for her disabilities. A clear contradiction that undermines the legitimacy of these proceedings. They aren't legitimate. It's a fruit of the poisonous tree since the inception. Additionally, the court, when they do this, they try this parallel construction crap. They say you're crazy. They want to say you're like schizophrenic or something. You can't understand anything. These people are freaking schizo. But anyway, additionally, the court denied all ADA accommodations and requests, including remote hearings, procedural modifications, despite its prior attempt to declare a defendant incompetent and admission that accommodations are necessary. And then, you got the judge denying my motions for e-signatures. So clearly the judge says, I don't understand the law. I'm going to need a competent, ethical attorney that understands the law. I mean, I do understand the law. But that's another factor that would point to the fact that I need, and I'm guaranteed the right to legal counsel. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, 12 attorneys will be appointed to throw your case, to screw with you, to have you thrown in jail. Because they're officers of the court, and their first obligation is to the court. So yeah. Additionally, the court has denied all ADA accommodation requests, including remote hearings, procedural modifications, despite its prior attempt to declare the defendant incompetent. An admission that accommodates... Should I put this on Do Not Disturb? Whatever. An admission that accommodations are necessary. This contradictory treatment violates the 6th Amendment, right to counsel, 14th Amendment, due process and equal protection, the Americans with Disabilities Act, that's the U.S. Code, prohibiting discrimination in public services, including courts. That's federal. If you look at the definition of federal, the etymology of federal, that's a covenant, that's a promise. But these aren't, they don't care about federal law. These aren't real courts. They give a flying F about this. And once again, this isn't legal advice. If you need legal advice, go seek out a competent attorney. They don't exist. This is just my experience. Sharing my experience is newsworthy, informative, educational. So legal arguments. The court previously attempted... I'm going to put this on Do Not Disturb. Hold on one second. All right. So if the court previously attempted to deem the defendant incompetent, it cannot now require her to represent herself. And I didn't even bring up Nelson and Ferretta in this. That was brought up plenty of times. They try to turn hearings that weren't about that into Ferretta hearings or Nelson hearings, and then they'd only do one at a time, but they never did them, and they would have to set more hearings to get the Ferretta part done after the Nelson part, when it wasn't even set for that, and then it just never happened. So the 6th Amendment guarantees the right to legal counsel, especially for defendants who may lack the capacity to defend themselves. Gideon versus Wainwright. That was in like 1967 in Florida. Like 50, 60 years old, however the math works out. They don't care about that. U.S. Supreme Court held legal counsel is essential to a fair trial. If the court believed the defendant was incompetent to stand trial, then she is not legally capable of representing herself under Indiana versus Edwards. The guy stole shoes, or allegedly stole shoes, and then fired at a store clerk or whatever. And then they found him to be schizophrenic, and he wanted to represent himself. I put the link to the case notes in one of my community posts if you're interested. Who would be interested in how the way this country runs in the 3 branches of government? You get every hooting and hollering over politics. And I'm showing you, everything's broken. Doesn't matter. They're all actors. It's a gang. It's a mafia model. So yeah, Indiana versus Edwards, where the Supreme Court held that courts cannot force self-representation on individuals who are deemed incompetent or borderline incompetent. And the fact that the court once sought incompetency determinations, but is now forcing the defendant to proceed pro se, is an incoherent and legally indefensible position. They keep contradicting themselves. They keep putting themselves in these and putting me in impossible situations because the law doesn't matter to them. They're going to run around and call themselves honorable. They're anything but. So denial of ADA accommodations while previously questioning competency violates federal law. Under Title II of the Americans with Disabilities Act, state courts must provide reasonable accommodations to disabled individuals to ensure equal access to the judicial system. You need equal access to the courts, fair and equal protection under the law, but they're going to deprive your rights under color of law. Which would be Title 42, section like 1983, Title 42 U.S. Code. They don't care about that. Still waiting on this judge's oath of office and bond. I've asked him 3 times. He don't have one. He does not have a valid oath. He don't want you to get that bond. He'll take mine, but I'm going to take his if he even has one. So yeah, Tennessee versus Lane. Supreme Court ruled that state courts are required to accommodate disabilities to ensure access to justice. That's the one with the guy in the wheelchair. The judge laughed at him, made him climb up the stairs, and he's in a wheelchair twice. And then got him for a failure to appear. Threw him back in jail. They don't care about that. The court's prior attempt to address the defendant's competency is itself an admission that accommodations are necessary. Yet the court has refused to provide ADA accommodations, including remote hearings, dismiss motions without addressing the defendant's disability-related limitations, impose procedural barriers that prevent the defendant from fully defending herself, failure to accommodate violates both federal law and fundamental due process rights. If it was a real court, they'd worry about that stuff. The court's actions amount to judicial bias and obstruction of justice. The place where you're supposed to get justice is obstructing it for nearly 3 years now. Just call it 3 years. It might as well be. And the court has created a self-contradictory legal environment that undermines the legitimacy of these proceedings. Yeah, since the fruit of the poisonous tree, since this thing started, there was no legitimacy. They're trying to set me up, put me in jail for getting beat up. Ignore exculpatory freaking exonerating evidence that's been submitted. All these lawyers have known about since I think since Pamber. It's the only one that actually did it, and she only got those medical records showing I was beat up to try to prove me as being incompetent. And it backfired on her. And I got people hitting me up all the time about her and what she's done. She's stolen a lot of money. If the defendant is competent, she is entitled to full access to legal representation and fair procedures. If the defendant is incompetent, she cannot be forced to proceed without counsel and must receive accommodations. By attempting to deny both, the court is effectively obstructing justice and violating the defendant's constitutional rights. Such inconsistency is strong evidence of judicial bias, which further supports the need for judicial recusal and intervention by a higher court. And it's got to be federal. It's got to be like an Article 3 court, so it's Article 1 administrative freaking kangaroo clown show. So wherefore, I move the court to clarify its position on the defendant's competency, either appoint legal counsel if it continues to acknowledge competency concerns, acknowledge the defendant's full legal capacity, and provide equal procedural treatment. Enforce ADA accommodations, including but not limited to remote hearings and modification of procedural requirements, written acknowledgments of the defendant's right to equal access in court proceedings, hold a hearing to resolve the contradictory rulings. So you're asking your rapist to investigate themselves and rule against themselves. It ain't going to happen. Provide any further relief necessary. But then I go ahead and I make sure it's double spaced. I use the Times New Roman like they want. They either want Times New Roman or Courier and like the 10 something typeset. Double space it and all that. And then the signature. He wants his signature. It's nothing about the merits, about my e-signature. So I e-signed it and signed it. That's probably a problem too. And they want my phone number, my address. I put down, defendant forced to appear pro se. Address is homeless no address. Phone numbers, that's my phone number. It's protected by the 4th and 5th Amendments, unlisted. There's my email. They should be redacting all this stuff. They never redact it. Once again, YouTube, this is all public information. There's no privacy concerns here. It's not legal advice. It's for educational, informative, and newsworthy purposes, if not entertainment purposes. So there we go. Put my certificate of service, Yeah, they blocked me at all these trials against my trustee, too. She never put certificates of service. She never served me. They don't care about the law. So I haven't signed it. All rights reserved. But that's today's story. Thanks for coming. Let me know your thoughts below. People are like afraid to comment on this stuff. It's crazy. This is your country. If they're doing this to me, they're doing it to other people. An injustice to one is an injustice to all. It's a mafia running this place.